Welcome back on the AM show, and of course we get into our big stories. And first we're going to be talking about that motion of censure vote from yesterday and all that happened. 183 votes required. The minority only had 136, and of course that walkout staged by the majority caucus. But what does it mean for our democratic experiment? What does it mean for our legal life as far as we are concerned? Now, joining us for that conversation from the Parliamentary Network Africa, we have Sami Obeng, who is the Executive Director. We also have Dr. John Osei-Kwapong, a CDD Fellow. And joining me right here in the studio, well, I'll be introducing him shortly. Let me welcome Dr. Kwapong and Sami Obeng, first of all. A very good morning to you, gentlemen.
Good morning to you, too.
Great. And in the studio, we have Bobby Banson, our very own Bobby Banson, a lawyer, and a man of many things. Good to have you in the studio.
Thank you for having me, Ben.
All right. So I'll start with you, Dr. Kwapong. I'm sure you followed proceedings yesterday. I'd like to know what you made of everything, maybe from day one, when this motion of censure was brought to bear in Parliament, the ad hoc committee sat on it, and now culminating in this fatality, if you like, because the motion was stymied, it died a natural death, and now we can proceed with life. But where do we go from here? What has been your appreciation of everything that has happened so far?
Oh, good morning again. I'm not particularly surprised at the outcome. From the onset, well, at some point when those MPP MPs came out publicly to also call for the removal of the Honorable Finance Minister, that was when I said, well, maybe they might join their colleague NDC MPs as part of this censure motion if the president doesn't accede to their request and maybe vote with them. But of course, subsequently, if you look at the turn of events after their meeting, after their reported meeting with the president, and they holding back until certain 2 or 3 conditions had been met, and then looking at how the process began playing out, that is when I said, well, I'm not sure they would lend support in terms of votes to the NDC caucus. And so I looked at it and I said the outcome for me was always predictable, which was there would be no support from the from the MPP MPs, and therefore, ultimately, the censure motion would fail. But one of the things that at least I appreciated about the whole process was that I've been asking myself, what happens after Parliament gives their approval to a nominated minister? It seems like there is no post-approval recourse to making, in terms of accountability when it comes to ministers of state after Parliament has given them the nod. It's up to the appointing authority to decide what to do in the event of any egregious misconduct on the part of a minister. But it looks like the censure is an inbuilt political process that allows Parliament to still have a say after they've given approval to a minister of state. And at least you saw that triggered, you saw that in action. But again, ultimately, I'm not surprised at the outcome. It would have to take, I was saying to someone yesterday that to get a bipartisan vote to censure a minister, after I watched the proceedings, it suggests to me that it would have to be something seriously egregious, like something very criminal in conduct, for example, is maybe the threshold that situation may have to rise to get both NDC and MPP MPs to say we would want to censure a given minister of state. But save for that, the process taught me that this is how it would usually turn out.
For you, Sami Obeng, what is your take, your appreciation of what happened in Parliament yesterday? I know you followed keenly. What does this reflect in terms of our democracy and maybe the law, reflection of the law?
Well, just like Dr. Kwapong, the first point on not being surprised, of course, I was not surprised either. His second point, which is also very important on the censure motion showing that beyond parliamentary approval of members of ministers of state, there are other routes to be able to hold them accountable. It's also very germane. And I will add that it helped us also to be able to fashion out the processes for going through a motion of censure, because this is a provision that has been in our constitution since 1992. However, it has not been triggered and has not gone through the full haul like it went through this time around. And even Parliament at some point was confused about how to go about it. It had to take the experience of Speaker Babin, the collaboration of the leadership to be able to carve out a process to take this through. And I think that was very useful. So going forward, at least Parliament now knows that there are areas in its own standing orders that it has to work on to be able to accommodate such processes going forward. And I think that's useful for our democracy, for our parliamentary democracy, going forward. It is also instructive to note that, it has taken us 30 years before this particular provision was triggered the way it had been triggered. And for me, even though it did not succeed in what it's requested to do, having a minister of state go through the process of Parliament wanting to pass a vote of no confidence in him, at a time when his own political party folks had also, expressed their lack of confidence in him, is completely shows that this is a process that would certainly be etched in our historical records. It may take another set of decades for a similar situation to happen, but this was good for our parliamentary democracy, no doubt about it. Finally, though, the openness of the process, the fact that we could watch parliamentary proceedings on TV and watch it on Facebook Live and what have you, allowed us also to be able to measure the voting behavior of our members of parliament, so that when push came to shove on a matter as important as the economy and how it has been managed and the blame that has been heaped on a certain finance minister for his lack of performance, we had 136 members of parliament representing a certain group of constituencies who showed up and voted. We had 138 members of parliament on the other side who showed up but did not participate in the votes. They abstained and sat on the fences. And so, of course, clearly this is with regards to what they think about a matter of as important as this. And I think that it now becomes an arrangement between them and their constituents to explain why they think that the finance minister in such a terrible economy, a minister who, had told us all the things that will not happen so far as IMF is concerned, and had made a very terrible U-turn that is costing the state so much, will still have to stay. I think that's between them and their constituents, really.
Let me come into the studio now, and thank you, gentlemen, for your initial thoughts. Let me find out from Bobby Banton what he also makes of what transpired yesterday and the entire process, Bobby, that we followed so far, even before we get into some of what the articles have to say. What do you make of the entire process?
Well, it's, for me, another evidence of the fact that our parliamentarians more or less think of their party principles than what is at stake for the country as a whole.
So you're basically saying they put party over country?
Over country, yes. And, it's, for me, I've always said that we do not have integrity in our national politics, in the discourse we have. First and foremost, if the MPP knew that they would have worked out, why did they participate in the committee meetings, all of those things, waste the taxpayers' money? Why didn't they boycott the committee sittings? They wanted to
ad hoc committee sittings.
Yes.
The 8-member.
The 8-member. Yes.
Right.
Because they had members on it. Mr. Katie Mensah was the...
Katie Hammond,
was the chairperson, co-chairperson as they call it. Yes, they did not boycott it. If you knew you were not interested in the process, why did you drag all of us along from the beginning and come this far and decide? You see, if your conscience is right, I always say sit and vote. Let the record show that you expressed your opinion on the subject.
Right.
I don't believe in parliamentary walkouts in parliament. For me, it does not do anybody good. If you think that the finance minister deserves to stay sit there and vote.
Right.
And let the record show that the members of parliament belonging to the MPP thought that in the midst of all the problems we are having, they sat down and they voted for the finance minister to be retained.
Quick question. Do you feel that was a hypocritical stance?
That is why I'm saying that we do not have
because
integrity.
they had said 80, 98, saying that, and if you add those numbers, even 80,
to the 138, would have crossed the constitution. 136
on the side of the NDC.
Yes, would have crossed the constitutional threshold.
So this was.
There is no integrity, and it's sad. Every now and then you see both MPP, NDC, and you see. I was thinking about it. You know, this is not the first time that the position of the finance minister has come up. When the MPP won the elections and he was renominated.
Indeed.
You remember the NDC saying that there was no way they were going to approve his nomination.
Right.
And then I remember it was Mr. Okujeto who said he resigned from that committee because of we never knew formally what happened,
right.
that resulted in the finance minister's approval. So you see the NDC, when it mattered most for them to also stand up against this same person 2 years down the line or 18 months down the line or so, they are now asking that he should be removed when they had an opportunity not to have even approved him in the first place for the same prophecies that have come to pass. Because they were saying then that, listen, the man has failed. If they look at the trajectory of what he's doing, he's going to lead us into a ditch. So they will not approve his nomination.
Is it then a failure on both sides? Because you would notice that we've criticized the minority sometimes for saying they'll do one thing and doing something else, like they did with the budget, but this time Isaac Adongo and others would say that, look, it's one thing setting aside an entire budget. It would have consequences for the nation. We've tried that before. We don't want to put the nation in some sort of, straitjacket. But there are taxes that we are never going to support. I don't know what you think about that. But in this instance, they actually went ahead, stayed in Parliament, and they knew that they didn't have the numbers, but they voted. On both sides, is it hypocrisy?
Yes, that is why I made the point.
What exactly?
That is why I made the point earlier that we've had evidence of the fact that when it really matters most, members of parliament put their party principles over national interest. And that is why I had to bring in the situation where NDC parliamentarians had an opportunity not to approve his nomination in the first place.
Right.
And they also chickened out, for lack of a better word. And they got him approved under circumstances that we really do not know.
Bizarre circumstances.
Bizarre circumstances because of what Mr. Okujeto said.
To a head.
Now it's come, yes. And then the MPP also say, or majority of them, 80. No, later the majority leader said most of them.
No, in fact, at the point, it was all of them. In fact, because even recently, the member of parliament for Anyaso Utuom, his name,
the doctor.
Yes. Yeah. His name just escapes me. He made it clear right here that, they haven't changed that stance. All of them are still on the same page. They just don't support the motion of censure.
How do they want
to? And that brings me to another question, which can be, what can we expect from them now, moving forward? Now that the finance minister has escaped the jaws of censorship. What can we expect from them? Because there are no timelines. We don't know. People have said, after the budget is approved and all of that. After the budget is approved is still a long...
I think first they said
he should
read the budget.
Yes.
He should read the budget. Yesterday was post the reading of the budget.
Right.
They had an opportunity. I honestly do not expect anything different from the MPP majority because it's been proven time and time and again that this is the closest you see party trying to, or members of parliament trying to put the nation first. But even with that, you see how they were able to be told into action or whipped into line. And then at the end of the day, it is the citizen or the country that suffers. I mean, I have not seen in the Fourth Republic any minister that has been subjected to such public discourse.
No, have I.
And then he still thinks that he has to commit a crime before he should be removed. It's not about committing a crime. It's about whether or not you can keep your word. You gave us your word, you have gone against it, and you say that it's like a father leaving the children. Where was he when Ghana found independence? Those who founded us if they thought that Ghana was their children or was a child, or Ghanaians were their children or the child, they would not have left their position till date. So I think that this is was an opportunity for the members of parliament to show that in situations like this, they will put the country first. But again, they have failed.
What do you say, though, just reminds me of Ofori-Atta, because some people have been praising him in recent times. He said that, kind of like the power minister, Dr. Donko.
Yeah.
When he said, I'll end this in 2015. When he didn't, he honorably resigned.
Yes.
And Ofori-Atta, of course, he had said that, look, whether we won the World Cup, when this ended, he would resign. And I've seen Nigerians praising him on social media that would that they had people like that. I think we ought to get there as a country. But let me go to Dr. Kwapong and just find out. So the member of parliament I'd been speaking of, though, was Dr. Adomako Kisi.
Yes.
Member of parliament for Anya Sowutuam. Do you think, Dr. Kwapong, by walking away, the members of parliament on the majority side, they missed an opportunity? And do you feel that if that secret vote had gone ahead, maybe we would have seen scenes like when the Speaker of Parliament was elected at the dawn of this 7th Parliament? Because then it was secret. And mind you, a number of the MPP MPs had said they were not for Ofori-Atta. Do you suspect that is why the walkout was staged, so that there would be no secret voting in the first place? So because then you don't know who voted what. What is your take?
I don't think so. I mean, you know, in parliamentary procedures, members of parliament always have different kinds of tools that they can resort to, you know, in the process of whether they want to participate or not participate in the vote. You know, they can walk out, they can stay, they can abstain, they can vote, all of those things. A couple of weeks ago, or maybe a month or so ago, when this censure thing first came up, this was even after those majority MPs had also said they wanted the finance minister gone. If I recall correctly, they had been asked about whether they would participate in this censure thing. And the sentiment was that whilst they are saying they want the honorable finance minister gone, they would not participate in the process as initiated by the NDC MPs, that it would be on sort of, they would carve their own way and their own path, you know, in terms of how they want him gone. We also saw what happened on the day that the motion was actually moved. There were, you know, party officials there to ensure that, you know, they all stayed in line. So I personally don't think that if they had stayed during the secret ballot, they would have voted to lend some support for the motion, unless it meant going back on what had been reported publicly, that they had said,
but if you notice, Dr. Kwapong, this was just a stance put up by the leadership of the majority that they wouldn't support the censorship. And of course, there are party whip systems and all of that, so you would follow. But when an individual is going into that booth to vote, just as with the Speaker of Parliament, and you don't know what they're thinking, and especially when there's agreement that the finance minister must go, don't you think they would have been thinking, this is an opportune moment, whether for this or for that? In the end, the result would be the same. Though I understand that eventually this motion would have ended on the table of Mr. President, who could have decided to approve it or do otherwise. But don't you think that would have been a statement they could make?
Yes, I mean, that would have been a statement for them to make. But I'm still not convinced that they would have cast a yes vote in support of the censure motion, unless what was reported that, you know, they said, yes, we want him gone, but not as part of this process, was inaccurate. But if truly those were their sentiments, that this is not the way we want to see him gone, which is by virtue of the censure motion, then I don't think the secret ballot would have made a difference.
For you, Samuel Bing, so looking at that development, do you think any differently? Do you think if the vote had gone ahead, we could have seen the back of Finance Minister Ken Ofori-Atta? Quickly on that.
The majority group in Parliament walked out purely because of that. In fact, they were not too sure about their members. Yes, as to whether we're going to have well over 40 members on their side show bravado behind that secret screen to vote in favor of the motion is a different matter, to be able to have the numbers for the 2/3. But certainly they were going to be surprised by one or two or a few members on their side, which was going to be something that they felt would be embarrassing to them. And so, yes, they walked out purely because of that.
Also, do share with me, where does this leave us? Because some have suggested, of course, that they want the Finance Minister, Ken Ofori-Atta, to go ahead and also execute an IMF program, after which then we can see his back, both as politicians and maybe as a section of Ghanaians. But from where you sit, is Ken Ofori-Atta still the right person to do that, to see us through an IMF program? There are different opinions on it. What is your opinion, Sami?
Well, the appointing authority, the president, thinks so. Interestingly,
what do you think?
Interestingly, his party thinks so. I really think that Finance Minister Ken Ofori-Atta should have been out of that particular office a long time ago.
For you, quickly on that, Dr. Kwapo, do you also think he should have been out of that office, even considering an IMF program? Some have said he is already there, he should see it through. Others have said someone can equally come through and see us to that point. What do you think, quickly on that?
Yeah, in fact, if I were him, I would just bow out quietly and let somebody else see us through. He served his time, and for me, this is not the kind of quote-unquote victory that I would personally have fought for. I think it's dragged, and I would have just quietly exited the scene for the president to find a different person to take over from me.
What do you think, for you, Bobby, what do you think should be the position of the majority now? After everything that has happened, what can we expect from them? Okay, so now let him read the budget, to let him complete the approval of the budget, the appropriations and everything, to let him conclude the IMF program. And that could lead into the first quarter of next year. We don't know what will come next. What are your expectations from the majority side? Because at least for the minority side, they've been clear on what they are looking forward to, whether motion of censure or whatever. What are your expectations from them? And do you feel Ken Ofori-Atta is the right person to get us past the Red Sea of the IMF program?
Well, I do not think the majority will be bold enough to, at any point in time, insist that the finance minister leaves or is sacked by the president. I do not think that the president intends to sack him. If he did, he would have done so long ago. And so that is why I still think that yesterday was a very, a missed opportunity. Yeah, that if the majority of the members of parliament had voted and the president decides not to sack him, then you'd have a situation where the president is directly going against the wishes of the people.
And so if that had happened, what you're basically saying is we could have stood back and said Parliament has done its job by the people. After all, they represent the people.
Exactly.
But it is the buck will now pass on to the president.
Yes.
Okay.
And if he did not, which I expected him not to do, but then it would have sent a clearer signal to the people that, listen, we wanted this man gone, and we spoke through our parliaments, our parliamentarians, in accordance with the provisions of the Constitution. And yet the president decides to go against the wishes of the 35 million people, or majority of the 35 million people also, as we have. I do not, and once we miss that opportunity, I think that, it will just be water under the bridge. There is no way I see the majority caucus or the majority side trying to, in any way or any form, force the hand of the president to terminate the appointment of the finance minister. And I certainly do not think that he will go on his own. I'll be very surprised.
You think Ken Ofori-Atta will never go on his own?
I will be very surprised, looking at how...
What makes you say that?
I think from his narrations, he thinks that if indeed he has brought us to this level, he wants an opportunity to take us out of it. To say that I took you there, I brought you out. But Ghana as a country...
So do you think it's an ego thing? Do you think it's a thing to prove himself?
I would want to say so. Because, you see, before he came into public office, he's been a very accomplished businessman. Yeah. And so to say that, okay, we handed over to you the economy of a country and you led it into a ditch. The country got the lowest ranking with the international agencies and you could not reverse the trend. I mean, it's a dent on his CV.
It casts a slur
on him.
And that's what you think he's trying to do.
That is why I think that he's trying to do whatever he can to reverse it.
But sometimes it's also about the optics. You may be good, and it's not to say that, I mean, most finance ministers, even from Professor Kwesi Botwe, who may his soul rest in peace, have had their own. But today, people acknowledge them as having been sound minds. It's just that maybe they couldn't get all the returns we would have wanted. So, I mean, no one man is a repository of knowledge, and no one man can do it all.
That is the position that I've always held. That, I mean, you have come, you said you are not interested in salary. You have done your best. We are not happy with it. You have promised us, you have failed. You should have some level of integrity. For me, it boils down to that. You stood before us and then you said, this is what will happen. It didn't happen. You should not have any business going back to your office. Imagine, like people keep saying, imagine if Ghana was a limited liability company owned by the president.
Right.
And Mr. Ofori-Atta was his managing director. And he consistently fails to deliver on his KPIs. Would he have kept him there?
That's the question, right?
That is the question.
If this were a private entity,
yes,
would you still retain?
Would you still retain your managing director or your CFO who keeps missing his KPIs? That's the question.
And he pulls the purse strings of the country. So tell me, how? Let's talk about the law a bit. I'll get into what the standing orders say, but the finance minister insists he is innocent of all the charges leveled against him. And interesting for me was the intervention of the AG. I've not seen that in Parliament so far in the Fourth Republic. The AG came there and basically held brief for Finance Minister Ofori-Atta. With all the things he said, how did you find that spectacle?
Well, I mean, if he's not a member of Parliament, he will not have audience unless the Speaker or the authorities in Parliament permits that. And I think that there was a decision by the Supreme Court that did not find anything wrong with the Finance Ministry. You remember when, or was it Shraj? You remember when there was, I'm not sure whether the suit was filed in the Supreme Court against the Finance Minister when by an NGO or so, when the objection was raised as to whether or not the Attorney General can represent the Finance Minister. I don't know whether it was Shraj or the Supreme Court, but there was that issue. There was a petition.
Reading of the budget at that time?
There was a petition against the Finance Minister for one of the things that had happened by one of the CSOs.
I think, yeah.
And then the Attorney General represented. Yes, and it was held that he had the right to that representation. So legally, I do not see anything wrong with the Attorney General stepping in to do that.
Okay. Now, having said that, let's look at what the standing orders say. So when you look at Article 82.1, Parliament may, by a resolution supported by the votes of not less than 2/3 of all the members of Parliament, pass a vote of censure on a minister of a state. It also says, of course, we know there are 275 members, and that would mean that they would require some 183 or 184 members of Parliament. In declaring the motion as lost, the Speaker of Parliament following the terms of Article 82.1, the vote is accordingly lost, and we all know why. Looking at what happened and the requirement for 2/3 majority of Parliament, would you say it's high time we took a second look at that provision?
I do not think so. I think that we do not want a situation where you will not have a clear majority being in favor of this motion, because you know how it can destabilize government, the role of the executive. The only problem that I have with that provision is the fact that even after Parliament has spoken, it still goes back to the president.
That's the problem.
That is the problem I have, because
it should be final when Parliament decides.
I think it should be final, because then it takes away the principle of checks and balances in our democratic dispensation, because the Parliament approves of, the Parliament is the representation of the people. And so if the majority, a clear-cut majority, 2/3 have agreed that a minister is not fit for his role, the minister, remember in the first place, having been appointed by the president. If the president wanted to remove the minister for the same reasons that the vote of censure is being tabled before Parliament, I believe that the president would have removed the minister before. And so to now ask the president to be the final authority, even after 2/3 of the parliamentarians have voted for such a minister to be removed, I think that it defeats the whole purpose of going through the censorship.
Now that, coming to you, Dr. Kwapong, we've got to, a crossroads, so to speak. It is clear that we're not seeing the back of the finance minister anytime soon. What would you say have been the benefits of this entire exercise as it has been practiced in terms of democratic practice, in terms of parliamentary work, and what would be your expectations moving forward on this to stabilize our economy, especially as we go in for an IMF program?
Yes, so I think for the first time that we've seen this thing really triggered and seen it all the way through, I agree with Bobby when he says, you keep the threshold at the 2/3. It's not something that I would want to.
We shouldn't tinker with that, should we?
No, because then you make appointees very, very vulnerable to, in the event of any partisan political mischief, it becomes really easy to remove a minister of state. But I would agree with him also when he says that you can tinker with the process to say that once Parliament has spoken, that should be the final say in the process, because it still goes back to the appointing authority, who can still decide whether he or she wants to then act upon what the Parliament has done or not, and it removes that element of accountability and oversight over the executive that we expect and legislative body to be able to fully exercise. But I mean, it's over, quote unquote, at least the process is over. The minister is still at post. The president has over a number of times indicated that he has no intention of removing him from office. So there are measures being put in place. There's an IMF negotiation still going on. I guess from now on, it's just, hoping against hope and hoping for the best that this sort of cloud that, that hangs over him, hangs over the country, all the angst, pinch points that citizens are feeling, hopefully, would be enough signals for the government to realize that they really must find ways to get things back on track. I've said over and over again that the path to recovery is going to be very slow and very painful, but that's the difficulty and the challenge of governing. It's for a government to be able to also get a country back on track, given how citizens are feeling. It's not going to be easy, but they don't have a choice but to really find a way or find ways to get the citizens feeling okay, at least again, over the next 2 years before we have the next election.
Stay with me, Dr. Kwapong. There's something else I want to run by you, not necessarily on this issue, but stay with me. For you, Sammy Obeng, on that same issue, what next? Where do we go from here?
Well, before that, let me clarify that the Standing Orders of Parliament grants audience to His Excellency the President, Vice President, ministers who are not members of Parliament to be able to speak in Parliament.
Right. We have a connection problem to Sammy Obeng. We'll just try to rectify that. Sammy, please go ahead.
Right. So I was saying that the Attorney General participating in the debates is allowed because of the category of people who are defined as not being strangers in Parliament. Ministers of state who are not members of Parliament are part of those categories. So he's able to debate on a matter in Parliament. He has audience without any special dispensation. Having said that, though, I think the process helped us to be able to put in place a process for that constitutional provision on censure, which has not been used since 1992. We've not gone the full haul on that particular thing. And so for me as a parliamentary practice and procedures person, I think was one of the very important aspects of this entire process, to have been able to carve out a process on how to go about this. Because remember that all the things that were put in place, including setting up the committee, the composition of the committee's work and all of that were novel. They are not things that are provided for in the standing orders. In fact, the Speaker, in his formal address to the House at the beginning of the process yesterday, indicated how they had to come about those and the reasoning behind these. And in Parliament, you need some of these precedents to be able to get things going in the future. So this is one of the very important aspects of what we achieved through the process. The second bit is that let's not underestimate parliamentary processes that takes place on matters as serious as this. You know, in the United States, having its parliament take former President Trump through that particular process of removing him, although it failed, that whole episode, that whole parliamentary records of something like that having taken place, you know, and considering that it may not, something similar will not take place for a very long time, is already a dent on any politician or any office holder who has been subjected to this. It took us 30 years of the 1992 Constitution for this process to take place on one Minister of State. Remember that we've had hundreds of ministers since 1993. It may take another 30 years before we get a minister who has underperformed so badly that this process will have to be triggered against him. And so we should not take for granted the other aspects of such parliamentary processes and what it means to, you know, politicians, to the entire country, and to the parliamentary records.
All right. Hold there for me, gentlemen, Mr. Obeng, Dr. Kwapong, for that final question. But for you, I'll throw same to you. So where do we go from here?
Well, we should keep pushing, expand the frontiers of our parliamentary democracy. I would want to see...
Do you think this exercise has done that?
Yes, I think that we have, yes. Whenever you always invoke for the first time certain constitutional provisions, it develops the law. For me, rather, I would want to see what the minority would do, not so much about what the majority would do. I would want to see what the minority would do going forward. Because, you know, there are situations where they also have the ability to, I don't want to say frustrate, but also make their voices known. And you'd have a situation where...
Have they done that already?
No, but going forward, because this is a situation where the most important agenda of Parliament now has to do with the appropriation bill, the budget, and everything. And the majority will need the cooperation of the minority, for lack of a better word, to get some of these go through easily. And so if the majority the majority have ensured that even their dissenting members have been whipped in line in such a very crucial situation, I would want to see how the minority would also collaborate or cooperate with the majority in some of the things that the majority would require their approval. And they would see how they will expand the frontiers of parliamentary democracy.
Whether it's going to be tit for tat, whether politics will be played, or like you said,
national
interest
exactly
will come to the fore. So I'll leave all of you with this final question before we get into some other matters. I found it interesting, and with all three of you here from the CDD, from the Parliamentary Network Africa, and you as a lawyer, I couldn't help myself. In recent times, at an IEA event, we had the question posed to Chief Justice Enin Yabua and former Chief Justice Sufaya Kufu about capping the number of Supreme Court justices. And it was interesting what they had to say. They said that, no, let's not cap it. But others have examples for us. Others say the numbers should be looked at because it appears there is some politicization. In recent times, we've also seen that report on 4 judges and 2 of them supposedly not making the cut, supposedly because of some political elements. I'll start with you once more, Dr. Kwapong. What do you make of it? Cap or no cap? And what are your reasons? That's the final question to all three of you.
Yes.
I'll say Bobby for last.
I will say cap. The Ghanaian situation is very...
So wait, you say you will say what? Cap? We should cap
I'll say cap it. Cap the number of justices that you put on the Supreme Court. The Ghanaian situation is very unique. I don't know why it's that open-ended. For me, my main reason is that whenever I study the rules, whether it's constitutional rules or legal rules in place in Ghana or administrative rules, and how our public servants or our public officials respond to it, it says to me that so long as the rule doesn't say you can't, it is interpreted as it means I can and I should. And I worry that if an appointing authority doesn't restrain him or herself, it can lead to what you refer to, which is the parking of the courts. And it's not a situation that, for me, would border well, to park a court with the politicization of a court, because that can result in that, especially because it's also a lifetime appointment. And so for me, I would support a capping of the number of justices that you put on the Supreme Court.
All right. Dr. Akakpo, we're immensely grateful for your time with us this morning. Thank you for always honoring our call. Dr. John Osai-Akakpo is a CDD fellow. For you, Samuel Bing, what is your quick take on this matter? Cap or no cap?
Oh, yes, it must be capped. And, ordinarily, having two people who have served in the office of Chief Justice, head of judiciary, suggests this, that it shouldn't be capped, ordinarily would have sent people asking the questions or concluding that, these are people who have been in that high office, and so they understand the dynamics in there and all of that. But this is a situation that can also be compared with many other jurisdictions. And for me, I find our situation of not capping our judges at the highest court of the land very, very, very untenable. I mean, we have evidence in other countries, here in Africa, who are common law countries, who have limits. Kenya has 7. You cannot go beyond that. And that is a constitutional provision. In Kenya, there are so many of cases that gets to the Supreme Court had to be dealt with within, an expeditious time. They perform creditably on this. You see, we are living in a country where the powers that be want to have limitless powers to be able to do anything and everything that they want to do without, being checkmated. And that must be stopped, because we want to have a situation where a president can appoint as many people as possible onto the Supreme Court, of course, provided that Parliament does not stop him or her from doing that. And we know that at least what has happened in our recent years has shown us that that really is not a sustainable situation. That really is a situation that can bring us problems, and we still want to go down that trajectory. I really, really, really find it very difficult to understand.
Thank you. Interesting thoughts you have. So, Samuel Bing is Executive Director, Parliamentary Network Africa. Thank you so much, sir, for your time with us this morning. All right. Let me come to you. So now, if we're in a court and you were the justices, it would be 2-0, so, or 2-1. I don't know where you stand yet. What is your take on that?
Maybe having the benefit of being a practitioner, I don't think it's a straightforward answer. Cap or not.
It's not a straightforward yes. No. It's not a straightforward no.
No. And let me explain, and I may take just a bit of your time. In the jurisdictions that have a cap, other countries, you will notice that the jurisdiction of the Supreme Court is very limited.
Right.
In our constitution,
there are other mitigating factors.
Yes. Yeah. And so you have only 7, and then the 7 will play specific roles, maybe interpret only constitutional matters. So you have a 7. You can manage with that. In our constitution, the Supreme Court has original jurisdiction.
Right.
To interpret and enforce the provisions of the Constitution. The Supreme Court has appellate jurisdiction. So if somebody starts a matter from the district court, except in parliamentary petition that can end at the Court of Appeal, the person can do the matter up to the Supreme Court. Yeah. The Supreme Court has review jurisdiction. And so that if the Supreme Court even delivers a judgment, on the stated grounds of the Constitution, that same Supreme Court must be empaneled by an increased number. Now, the Supreme Court also has supervisory jurisdiction over lower courts.
The other courts.
So that to do certiorari, mandamus, and what have you. And so in our Constitution, the Supreme Court has all these jurisdictions. And so if you have only 7 members or only 9 members, and they are invoking the jurisdiction of the Supreme, or people are invoking the jurisdiction of the Supreme Court in all these cases, in a week, if you see the course list of the Supreme Court, and then you see that they are sitting 5 members, and they have to write judgments. If you read some of the judgments, you would have a judge writing 42 pages on one decision. And assuming there are hundreds of appeals, and you have only 7 judges discharging all these duties, it will be problematic.
And we also know that we must always have an odd number. So what if something happens, one is incapacitated or something?
They'd have to adjust.
And maybe you are ruling on let's say, election petition. It means more turmoil.
Exactly.
You have to adjourn.
That's what I'm saying, that it's not a very straightforward. We should look at those countries that in the United States, it's a lifetime appointment.
Right.
The jurisdiction of the Supreme Court of the United States is also very limited because they have a federal system. And so matters do not just come there. There are very limited circumstances where their jurisdiction can be invoked. I think that we should look at the root of the problem.
Right.
The reason why this issue of it should be capped, it should not be capped, is because we think that the executive is abusing that power. But thankfully, the Constitution puts a check on the executive. So the executive can, even Chief Justice can be nominated by the executive, and the Parliament would have a right to disapprove it.
Yeah.
And so we should look at letting our parliamentarians do their work well in our current dispensation. And let me tell you interesting facts.
So as you cap off with that, just tell me that, but also tell me very briefly so we can talk about whether maybe we should also look at our Constitution, whether we've created an all-powerful Supreme Court, and maybe we should look at clipping some of its wings. And I say this not in any bad taste or with any...
Not to be cited for contempt.
No, not to be cited for contempt. But, you know, the whole purpose of Baron de Montesquieu and everything they said about separation of powers and all of that was to ensure that no one entity would become too powerful. Looking at our political dynamics, are we there? Are we getting
with
there?
The Supreme Court?
Yes, specifically to do with the Supreme Court.
I don't think so. I think, in fact, they are the only organ that will keep the scales of power in check.
Right.
I think so. I was going to make a point that the issue of the abuse. Do you know that the first, the father of the current president, who was the Chief Justice, was a political opponent of Dr. Kwame Nkrumah, and yet it was Kwame Nkrumah who appointed him to the Supreme Court. He was a political opponent of Dr. Kwame Nkrumah, and yet it was Dr. Kwame Nkrumah who appointed him to the Supreme Court.
You're talking of Edward Akufo.
Yes.
Right.
And so you would have situations where we over-politicize things sometimes. That is why when it comes to even the minority or the majority always trying to, depending on how the decision go, put a political, that, oh, this person was appointed by this person, and that is why his decision went this way. I always tend to, because this is the only organ that can keep the two other organs in check.
Okay. We'll wrap it there, that leg of the conversation. I know when it comes to the law, we'll sit here and talk. So let's wrap it there. But there's something else that is exciting, and we definitely are excited about this. Is this your first book?
Yes. After numerous peer-reviewed articles, this is my first book.
So can I just take a look at that copy? This is interesting. Civil litigation in the High Court of Ghana. It's a pretty bulky one. We're looking at how many pages do we have in here? Over 500 pages. Hey, I'm on for with you. So what this is a book you've put together, which you're actually launching today.
Yes, today.
At the Mövenpick Ambassador Hotel.
Yes, absolutely.
Tell us about how this book was born.
Well, it's during the pandemic when they were closed down with the courts.
Oh, you are one of the beneficiaries.
Yes. So my colleagues in the office and myself, we normally would maybe twice or three times a week just join Zoom or in person, discuss developments in the law. And I noticed that we were making interesting points. So we said, okay, then why don't we put all our thoughts into some form of book and put it out there? So that is the results of it. And more so, I have been involved in teaching civil procedure in the law school, Makola, for the past 5 years. I had the benefit of teaching with the current Chief Justice, the late Justice Mafosao as well. Okay. And so it's born out of my experience.
You taught that with him?
Yes.
Civil procedure.
Civil procedure. So it's born out of my experiences with being involved with the teaching of the course, how students perceive it, how young practitioners perceive it. And we try to put together something that would make the course, people have the perception of it. So it's basically about the rules of court. And no matter how good your law is, if you want to be a practitioner, litigate, and your knowledge of the rules of court is not solid, you cannot make it to the court.
It will always
throw you out. So they say that technicalities, but it's part of the rules. I always say that is what differentiates us from other professions. It's not enough that you are right. You must know how to present your case. And so we tried to put together a piece that would be make it in simple terms. So we as much as possible avoided using legalese, broke it down into very simple language for not only lawyers and students,
I was about to
but
ask
also
that.
for people interested in litigation, civil litigation, so that if, Ben, you take it, you see that you don't have the usual legalese in the book. You can read it. Because we've seen instances where people decide to pursue their own case without lawyers.
Yeah,
and
to represent themselves.
To represent themselves. So they should have something like a manual, for lack of a better word, that will explain in simple terms what the rules of court require from them and the steps and the procedure to adopt.
On this note, I have seized this copy. With this permission. Anyway, so, and I was just about to get to that, because the legalese, legal speak, as some would put it, oftentimes it puts people off. But this has been broken down.
Yes, we do not have, we, as much as possible, avoided using legalese, because like I said, that is one of the things that we noticed really discourages not only ordinary non-lawyers, but also lawyers. It always makes it some way, as they say, to understand the rules of court.
For lawyers who are practicing, who are hoping to practice, what then would be the benefits of getting a book like this? I want you to break it down for them. What can they expect if they decided to come by Mövenpick today?
I think that they would have the benefit of a book that goes straight to the point, as practical as possible, with a lot of practical examples. So we've not only stated what the rule is, we've also explained it in simple language, supported by authority, case law, and where the situation requires, we've added templates to the book and examples, so that you see how so we've spoken about the law, how it applies, and how it's interpreted and how it's applied. So you have a one-stop book that does not tell you only what the law is. It also tells you how the courts have interpreted it, how it's been applied, and gives you scenarios where you can also use to apply it and then appreciate the concept better.
Okay, we'll end with where it's going to be launched. I've already mentioned it and what we can expect. But beyond that, where is this book going to be stocked, so that maybe someone may not be able to pass by today, but will want to go to the...
they will be available in all the major legal shops. So there are some of them in the law school campus. They have a bookshop, all the major faculties as well. It will be launched today under the chairmanship of Professor Richard Opon. He's a very respected Ghanaian. He's a fellow of the Ghana Academy of Arts and Sciences. Yes, a very respected Ghanaian professor. The guest of honor would be the Deputy Attorney General, Honorable Diana Sonabadapa. And we expect to have a lot of colleagues and legal personalities and even non-lawyers. I have had some non-lawyers who are coming. Wow. And it will be an interesting networking session beyond the book launch.
And the start time is?
11 a.m.
11 a.m.
Yes.
Mövenpick Ambassador Hotel.
Ballroom 1.
Before 11 a.m., all roads lead to the Mövenpick Ambassador Hotel. Let's all support Bobby Banson for this bit that you've put together. We're proud of you.
Thank you. Thank you for the platform, and thank you to the multimedia group always standing by us. Yeah. Fearless journalism.
So we need to hear. How for you? Bobby Banson is a lawyer, and that's how we wrap the conversation on this bit. But there's a lot more to come right here on the AM show. If you've ever thought about the Core FS mixture and matters arising, we have very interesting conversations coming up, after which we shall engage you and find out what your thoughts are on the issues we've been discussing. Do stay with us. We'll be right back on the AM show.